Oops. Hello. I guess it works better with the mic on. Welcome to today's IP update webinar. In case you wonder, you are listening to people from Altius. If it's not the right place, you can still switch off. And if you have nothing to do and it's not the right place, please just stay and hopefully you will enjoy the talk. So today, Lora and myself, I don't know if you see Lora because I don't see nothing, I just see my screen, but you will see her later on if you don't see her right now. We will talk to you about trademark law and circular economy. And as you can see from the title on the slide, it is the question is, can sustainability goals always justify repair, debranding, rebranding, and upcycling of branded products? That's a big question, and hopefully I'm not sure we will give you all the answers and that you will go back with certainty to 100 degrees percent, but hopefully we'll give you some hints and tips that will help you to see a bit clearer to answer that question. So before leading you to the plan and then giving the word to Laura, I just wanted, or will I say that, to put on a little disclaimer. First, we are not here to be for or against anything. So we are not here, advertising for trademark and of sustainability. We are just here to give you kind of an image and an overview of the state of things to date, based on what the law is to date. So of course, we are super pro sustainability, but we are also super pro trademarks. And so don't take what we say as being an opinion to be for or against something. And that being said, now we can go through the plan, quite a simple plan. As you can see, first with Laura, you will go a bit back to the basics in order to understand, of course, the answers that we'll try to give you to the questions. Well, we have to understand first what we are talking about. And then still with Laura, you will review what are the potentially problematic use that a third party will make of somebody's trademark within the framework of sustainability. So I mean claiming sustainability argument. And then at the third section, Laura will analyze and review briefly with you if upcycling, recycling and stuff is risk-free. So what are the risks actually that are faced by the upcyclers, recyclers and so forth. And then Laura will pass on the word baton back to me. And I will review with you what are the possible defenses that the recyclers, upcyclers, and so on could use to defend themselves against trademark infringement. And then we will dive in the case study of existing decisions to date. And we will then conclude. That's not super original, but that's what we will do, and give you a few recommendations so that you can go back home a little smarter, hopefully. So Laura, this is for you.
Yes, hi everyone. So as Sophie has introduced myself, I'm Lora Arifagic. I'm a lawyer in the Altius IP team, and I will be explaining you now the basic general principles of trademark law. So as you all perhaps are not familiar with trademark law basically grants a trademark owner an exclusive right to the use of their marks in a commercial context or in the course of trade. And it actually prevents third parties which do not have consent to use the same trade or a similar trademark in the course of trade in relation to specific goods or services. Now, this right enables trademark owners to oppose the unauthorized use of a sign which is identical or confusingly similar to their own trademark. And these exclusive rights are rooted in Article 5.2 of the European Union Trademark Directive, and also in the Article 9.2 of the Trademark Regulation, which basically ensures a very broad protection for trademark owners. However, of course, there are, let's say, all of these rights are subject to conditions, but also to exceptions and limitations. So that brings us to Article 14 of the same directive, and also Article 14 of the regulation, which states that certain uses of trademarks are actually allowed without infringing the trademark rights. These exceptions are very crucial for enabling the resale of trademark protected second-hand goods, the sale of accessories, and also the availability of spare parts. So it's quite crucial that these exceptions exist. Now, when it comes to one of the most important principles and doctrines in trademark law, it would be the exhaustion doctrine, which is also sometimes called the first sale doctrine. And this exhaustion doctrine, it basically means that trademark rights, so these exclusive rights, are typically exhausted after the first sale, so after the first legitimate sale of the goods within the European Economic Area. This also means that under this first sale or exhaustion doctrine, the IP owner actually loses control over the resale of the original goods. So this means that even though this principle would not, of course, apply to when the product has been altered, such as through repair, refurbishment, or upcycling, which we'll be talking about later on. So if the alteration significantly changes the nature of the product, then of course this resale might no longer align with the original trademark's use, which potentially also leads to consumer confusion. And in that scenario, so when the product has been altered, in such situations, it actually constitutes an unauthorized use, and the resale might be contested by the trademark owner. So this then does not fall under the first sale or exhaustion doctrine. So to summarize this doctrine, I would say that the general rule is actually that after the first authorized sale of the trademark protected goods, the trademark owner has no longer control over subsequent sales, and subsequent sales will not amount to a trademark infringement. That's the general rule. However, the exception, as stated earlier, this means that the first sale doctrine would not apply if the products are being resold that are materially different from the goods that were sold. So that would be an exception to the general rule. And this is, of course, very important when it comes to legal implications that should be considered when altering somebody's trademark protected product. Now, this brings us to the next topic of sustainability. Yes. So a very interesting link can, of course, be made with the fast fashion industry. So let's briefly define the industry, the fast fashion industry, as an industry that thrives on rapid design cycles, inexpensive manufacturing, mass market accessibility. And also in this industry, intellectual property is very important and very crucial, as it, on the one hand, it protects designers, and IP actually ensures a fair compensation for these creative designing efforts, and it also protects against unauthorized imitation. And this is also very crucial because weak protection actually leads to increased piracy, resulting in cheaper counterfeit products, the value of the original designs, and it could potentially also saturate the market because more products are actually available. So while fast fashion has also positive sides, it of course caters to consumer demands. It also makes sure there is more affordable and novel products. It of course also simultaneously accelerates waste generation, and it actually undermines the longevity of fashion items. So in response to the fast fashion industry, let's state that there are quite some green initiatives which have been promoting circular economy practices like upcycling and recycling, which we'll be discussing later on. And these green initiatives, they actually seek to counteract these detrimental effects from the fast fashion industry. However, even though they are very positive as an initiative like upcycling and recycling, they often do, of course, infringe trademark rights. So that's also a very important thing to keep in mind when following along. So when it comes to the legislative framework of sustainability and these green initiatives, I would briefly point out Article 37 of the Charter of Fundamental Rights, which is a very cornerstone, crucial provision in this regard, as it acknowledges the importance of environmental protection by actually, this provision actually calls for integrating sustainability into EU policy, and it fosters practices like upcycling, repair, all of those things, in order to add value to discarded goods and to reduce waste. Besides Article 37, we also have other green initiatives at the EU level, such as the Circular Economy Action Plan, which was published in 2020. And then we also have the European Green Deal. And besides those two more general, let's state, initiatives, We also have two very specific green initiatives to support environmental protection, such as the Repair Directive, which was published earlier this year, and also the EU Strategy for Sustainable Textiles, which actually very specifically aims to minimize waste and promotes resource efficiency in the context of textile industry. So those are very important initiatives in this regard. Now, when it comes to sustainability, as said earlier, Article 37 of the Charter really embeds the protection of the environment and sustainability, and it integrates it into EU policy. However, of course, the right to property, including intellectual property, is also very strongly safeguarded under the same Charter, namely in Article 17.2 of the Charter, which eventually creates some form of a balancing act between environmental goals and then also the protection of trademark owners' rights, such as trademark protection. So courts have to rely actually on some type of balancing act, and there's also the principle of proportionality to determine whether limitations on certain rights, such as trademark rights, are actually justified in the context of broader social rights, such as environmental protection and sustainability. So it's very important to note that both rights are embedded in the Charter, and there should be some type of balancing act to determine which prevails. This then brings us to the very interesting discussion and topic on what types of use, reuse, alteration of trademark protected products exist. So we'll be starting briefly just to highlight the first one. It's basically the sale of second-hand goods, which are trademark protected. So one question that could be asked, of course, is it problematic to use trademarks on these apps? And we will see, Sophie will discuss these forms of reuse, such as second-hand sales, in depth later on. But it's important to state that, as I discussed earlier on, Article 14 of the Trademark Directive and of the Trademark Regulation do state that such types are actually exempted from the exclusive right of trademarks. Then I think by far the most famous and talked about concept is upcycling. I will briefly explain the definition perhaps of upcycling, and then we'll go over some examples, some illustrations. So upcycling, basically it means it is actually the process of transforming used items into products of higher quality or value. So unlike recycling, which breaks down the items into raw materials, upcycling actually retains the original product structure and enhances it creatively or functionally. So there are also two types to be distinct from each other. The first type would be the perhaps less problematic in this discussion. It occurs when a manufacturer uses a branded product as a component in his new product, but he only refers to the trademark in his advertising, labeling, or his components list, for example, but the manufacturer does not incorporate the original branding, the trademark protected branding, into its product itself. While the second and potentially more problematic type is actually when a manufacturer uses a branded product as a component in his new product as well, but the trademark would still be visible. So in this scenario, especially, the question arises whether there's any potential to cause confusion if it is not properly explained which products, which branded products you are actually using. And then on the slide, you can see two examples. One is actually the Louis Vuitton design, which is incorporated. So you can see the bag on the left. And this leather is actually with a design and the trademark of Louis Vuitton is actually incorporated by a fashion designer called Durand Lantink. And he actually integrated the leather part in the coat. So of course, here as well, there might be some confusion for consumers whether or not this product originates from Louis Vuitton or not. And then on the right, you can see an example of the famous Levi's jeans. and the pockets are actually being reused and stitched to a pillowcase. And here as well, you can see that the visible trademarks are being reused on the upcycled goods. And there might be a risk of consumer confusion about the product's origin or perhaps an association. I would be personally a little bit confused, but Sophie will also dive into that later on. Then when it comes to a second very interesting topic, that's debranding and rebranding. Debranding, it's also both are actually also two forms of reusing a trademark protected product. So debranding actually means that you would remove all the branding from a product, often followed by rebranding. And rebranding then means, of course, that you would alter the branding or identity by, for example, putting on your own brand or another trademark on the product. Now, the illustration is also very handy here. You can see that Mitsubishi, they sold a forklift, they made a forklift, and Duma bought it. And they altered the goods by removing the brands. They changed the product actually to comply with EU regulations because they wanted to resell it in the EU. And then they replaced the plates and serial numbers and applied their own brands. So here perhaps also the question can be raised, will this alteration potentially constitute a trademark infringement? And does this brand removal actually impair the trademark functions? Would a consumer be confused by the origin identification of the product? Would he still think that he's buying a Mitsubishi or a Duma product? So that's also very interesting. Then to the last example of reusing or altering somebody's product is repair. So repair is to me a very interesting one, as a repair is usually just the restoring of the functionality, and it is generally not seen as a problematic thing, but rather as a sustainable practice. And consumers typically also expect that used products are degraded from their original condition, and that they even may contain replacement parts. So if you would buy, let's say, a repaired branded product, usually it comes with less problematic implications. On the left picture, you can also see that certain businesses are predominantly busy with repairing and reselling trademark protected cars, for example. However, of course, on the right, you can also see that the nature and the extent of the repairs does play a very significant role, as it could have an impact on the trademark. So on the right, you can see the famous Togo couch by manufacturer Ligne Roset. And a company called Vitesso, they repaired the product. They added new foam, they added a new zipper, perhaps they altered the design a little bit. But most importantly, after they altered the design of Ligne Roset, they actually re-added the Ligne Roset label. So one could also wonder whether this actually confuses consumers, because they might think that they're buying a Ligne Roset, but a repaired Ligne Roset couch. But perhaps it's confusing as it lost the quality, perhaps, that the original trademark owner had in mind. So that's all very interesting. And Sophie will also, of course, explain it later on. Now I will briefly discuss what actually a trademark infringement can be and what the associated risks are. So here on the left, you can see actually all different scenarios of infringement with the conditions in the left column. And then on the right, you can see the associated risks. So these vary perhaps per situation. On the left, you can see that if you're using a trademark, if you're using a sign, let's say, that is actually identical with the trademark, and you're using it in the course of trade for identical goods or services, then the risk associated with such use might be that there is a double identity and that a consumer is very confused about the origin of a product, and all the other things as well, that the quality perhaps cannot be guaranteed. Then situation B actually means that you would use a sign which is identical or similar to a trademark, that you're also using it in the course of trade for identical or similar goods, and that there is also a likelihood of confusion. And then in C, you could say that you would use signs which are identical or similar to the trademark, irrespective of the fact whether the goods or services are actually identical or similar. So that's not important here. But then you do have the three extra conditions, namely whether the trademark has a reputation, whether it is used in the course of trade without due cause, and whether there's any unfair advantage or detriment to the trademark. So in these cases, it's very important that such alteration and the reusing of a trademark or the sign that is similar to a trademark can have very important consequences for the trademark owner, such as, for example, post-sale confusion, meaning that when products appear to come from a trademark owner, but they actually do not live up to the standards that consumers expect from that trademark, then of course consumers might lose trust, thinking that the quality has diminished. So that's very important to keep in mind. The second very important aspect is the dilution of trademarks, namely that especially for higher end consumers, I would say that a part of a luxury brand is a certain level of exclusivity. So if the market is actually flooded with products that appear to come from that brand, this exclusive image can quickly be reduced as the fashion trend is becoming actually accessible to the general public. And then the third very important legal consequence of using somebody's trademark or a similar sign would be the diversion of sales, namely that, of course, if more upcycled products are present on the market, this could impede sales by the trademark owner themselves. And as many of these products look similar to the original purchased goods. So this is very important to keep in mind. And now my colleague Sophie, she will explain further the possible defenses and then also the CGU's case law, which is very crucial in this regard.
Me again. And I realized that I forgot to make a little point of intendance. I don't know, we say that in English. If you have questions, and you may have had questions, since the beginning, well, I don't see them, and Laura don't see them either, so we won't answer. But actually, it's put your question in the chat, and if we have a few minutes at the end of the presentation, we'll make sure to answer them. And if we don't have a few minutes, or if you just all fled because you wanted to go back to work, you can, of course, still send us an email, and it will be our pleasure to answer to a limited extent. We won't send you a memo, but we will make sure that you understand and you have an answer to your question. So back to the presentation. So Laura just explained you the risk that a reuser, reseller, recycler, upcycler, whatever you name it, is facing, and what could those upcycler and so on use as a defense to defend themselves against a trademark infringement. So I'm not going into the case law yet. I'm still speaking more in theory. So first of all, they could say that they don't use the sign in the course of trade. So Normally, you should remember from what Laura just told you when she examined, the condition to a trademark infringement, that the sign, in order to be potentially infringing, must be used in the course of trade. So the upcycler, I'm going to use the word upcycler and not all the others, could just say, I'm not using the sign in the course of trade. But what is to use in the course of trade, actually? To use in the course of trade is when you use for a commercial activity with a view to economic advantage. So usually it's quite easily, you can just oppose in the course of trade to use for private reason, for private matter. So that's something that has been settled by the ECJ, the European Court of Justice, among others in the Google Friends case, and then that has been repeated and repeated and repeated. So if the upcycler is using somebody's trademark in the course of trade to make money, so to make a product that it will then sell, then there is a fair chance that the defense no use in the course of trade would not hold the test. And also, little clarification or precision is that when we say in the course of trade, it's in the course of the user's trade. So that's, for example, when you have a referencing service provider as Google, so that's a precision that has been brought in the Google case of 2010. Well, Google to some extent uses a trademark, but the court has ruled that it didn't use a trademark for its own trade. It was putting a services at the disposal of the real user so that the real user could then use the trademark. So it's using the trademark for your own trade. So if you are just an intermediary, of course, that's an all other topic, because sometimes you may present yourself as an intermediary, but you may actually do more than that. But if you are just an intermediary, you won't be considered as being the user. So the second defense that the user could oppose is that he doesn't use the sign as a trademark. And again, when you go back to the definition of, what are the trademark owners' rights and when can they be an infringement, the sign must be used as a trademark. And what is to use as a trademark is to use in relation to goods and services in order to identify and to link a specific company to those specific goods and services, okay? And so, for example, a upcycler could say, oh, but I'm just using, for example, Louis Vuitton trademark as mere decoration. So I'm not using it as a trademark, I'm using it to decorate my product. Again, that's something that will have to be assessed case by case. And in some cases, it may be that this decoration argument will hold the test, but in a lot of cases it won't hold the test because the trademark use, and even more if the trademark is super distinctive and or is quite reputed, then of course it will be really hard to pretend that it is used as, and that it will be most importantly perceived by the consumer as being purely decorative. And I put here the reference to the European Court of Justice case Adidas Marca. For those of you who know, that's quite an old case, but that's a case that still makes sense today, where Adidas, you may know, that's the famous 3 lines brand with stripes. Sorry, I'm not super fashionable. And Marca actually commercialized at the time 2 stripes. I think it was a sweater or something. And Marca tried to say, but I'm using the 2 stripes merely as a decorative element in my sweater. And the court, well, it's not the court that decides, but the court clearly led the way to say that it will not be considered as being purely decorative. And the third defense that the upcycler, recycler, and so on could use is the referential use. Lora has told you already that we have the right, that the trademark right, that is exclusive, but that exclusive right is not absolute. And so the law has foreseen a few exceptions, a few limitations. And one of those exception limitation is the possibility to use a trademark to identify, to refer to the trademark owner in order for you to be able to indicate to the public what are your goods, what are your services intended for. For example, the car reseller and the garage that was in one of Laura's last slide. They use, for example, Mercedes and whatever, they use it. Well, so they say, we'll see if that holds the test. They use it to say, not we are Mercedes, but they use it to say, we do repair and Mercedes, for example. So we can help you if you are a Mercedes owner. So that will be the third defense. And the fourth, sorry, I was jumping too fast. And in all those 3 cases, so be it the use in the course of trade, the use as a trademark, and other referential use, each time, and that's super important, it may seem a bit accessory, but it is not, because in practice, this last element that appeared on your screen is really one of the most important, is that the use must be made in accordance with the fair commercial practice. So each time the court, when it is seized with the case, will have to go and see if, based on the fact and under circumstances, the sign is used according to the fair commercial practice. So what does that mean? It means that there must the way you use a sign, the trademark, must not be confusingly to that extent that it gives the impression that there is a commercial affiliation or connection with the trademark owner. It must not take unfair advantage of the trademark reputation, for example, and nor it must not be detrimental to the trademark reputation either. So that's really important. So that's why I was saying we won't bring you a no or yes answer. So you won't go back to your work like with a clear idea of what you can do, what you cannot do, because it's a factual assessment each time. And then the last possible defense that could be opposed in order to say that the use of the trademark that you make is okay is the most commonly invoked defense. It's the exhaustion of right, to which Lora told you also that we can refer to the first sale doctrine. It's mostly, I think, the name that is used in the US. And so, just for a reminder, in case you didn't listen well to Lora, that what is the exhaustion of rights is that normally the trademark owner has the right to first put his goods under his trademark on the market. And this exhaustion of right theory, and that's an important point for those of you who don't know. I don't know who is there since I don't see the participant names, but this exhaustion of right theory is limited to the EEA territory. So if the goods So you have the right as a trademark owner to put first the good on the EEA market. And once you did it, it is considered that kind of you got your return on investment. So you got what you paid for your product. You got the advantage linked to the product. And that after that, you kind of lose control of the subsequent sales of that specific product that you put in the EEA market. But just so that you know, if you put the product out on the market, but outside of the EEA, so for example, if you sell a sweater in the US, then you still have the right to first put it in the EEA market. So that's really the right of first sale within Europe. If you already sold a product and that it is authentic, but that it was sold outside of Europe, you still have the right to put it first in Europe as trademark owner, okay? And so if the trademark owner put it first on the market within the European territory, then in principle, he loses the control over any subsequent sales. So in principle, any upcycler, recycler, debrander, I don't know if you can use that word, should be able to use the product and using the trademark that was affixed on the product. Unless, each time we have a rule, there's an exception, as Lora told you, unless the trademark owner has a legitimate reason to oppose further commercialization of its product, okay? And when will the trademark owner have legitimate reason to oppose? First, the law expressly say, and maybe I should have put the example first, the law expressly refer to the fact that in case the product is altered, the condition of the product is changed, it is given as an example of legitimate reason for the trademark owner to oppose further commercialization. We'll come back to that. You will see it's an example and a condition that is frequently used in the case law. And a second example is when this subsequent sale misrepresent an affiliation or a connection with the original trademark owner. So there is a kind of a risk of confusion within the mind of the consumer that thinks that this upcycled product, recycled product, rebranded product, whatever, is linked with the trademark owner, and that is confusing that's confusing for the consumer. And again, as said for the three other defenses, it's a case-by-case assessment. So here again, there is no, it's not black or white answer. I cannot give you certainty. It's really a lawyer argument to say I cannot give you certainty. And now a bit of a case study. So as you will see, we will first go review a few cases that are closest to home. So we'll review, as Lora said, a few cases from the ECJ, so the European Court of Justice, and we'll also review one or two cases from Belgium and also an interesting case from the Netherlands. And I will also refer to our neighbor from Paris. And afterwards, we will review a few cases, not really go deep into the details, but a few cases that happened in the States, and or a few cases that are not really judicial cases as such, but where there are questions that could be asked. So the first case that we'll go with is a Belgian case, and it's a case of, among other things, upcycling and second-hand use, okay? So that was decided before the Commercial Court of Brussels, the Dutch-speaking section of the Commercial Court in 2021. And the case opposed Rolex, which I think I do not need to present. I cannot say that I own any Rolex product, but I think that the brand is sufficiently well known for me not to introduce Rolex. And the opposing party, the defendant in that case, was Timeline Watches. So Timeline Watches is a company that is specialized in the sale of second-hand luxury watches, and both unaltered watches, so the original watch just resold, and alter watches. And you can see, for example, an example of the alter watches that would be sold, for example, on Timeline Watches. On the left or right of your screen, I never know which side you are looking at, but anywhere, I think you know what I mean. So you can see that some of the watches that are proposed on the Timeline Watches website, they put little diamonds and gemstones in it. And here they even kind of designed tiger. Well, you like it, you don't like it, that's another question. But so that's a fact, okay? And so we'll see that Timeline Watches use the Rolex trademark made several use of the Rolex trademark, so to promote and to offer for sale the Rolex second-handed that it sold on its website. So first, we have use of the trademark on the website itself. As you can see, for example, the black banner that you see on the bottom of the screen is an example of a banner that you can find on the website, and where you have the trademark Rolex that is used as such, so the semi-figurative trademark with the logo and the word. And you also have the use of the trademark on social media. And here, more specifically, what we had is that Timeline Watches was using an original photo that indeed came from Rolex, and for which Timeline Watches didn't ask permission. And on this photo, and next to this photo, it's not clear because I didn't get a chance to see it and I didn't find it. There was a glove on which the Rolex watch was posed, I think, and this glove was bearing the Rolex trademark, but actually it was fake. So the trademark was apposed on the glove, I guess, by Timeline Watches. And in this case, we see that Rolex is okay with some of the use of the trademark. So it's okay, of course, that the trademark appears on the used watches. So you see on the bottom, yeah, if the watch is sold as such unaltered, of course, Rolex is okay that the brand is still on the watch. And it's also okay in Rolex mind for a Timeline to use a trademark, but in normal letter. So Rolex opposes the fact that Timeline will use a trademark with the logo, and so the specific semi-figurative trademark. And it opposes also the fact that Timeline will alter the Rolex original watches. So those are the facts. So what is the decision that has been taken by the court? So the court first decided on the alteration of the Rolex watches. And here, actually, I would have loved to be more prolific and give you a lot of explanation, but the court just said there's an infringement. So we can assume that the court based its decision on the fact that there is an infringement on the exhaustion theory, and more precisely on the fact that in principle that's the exhaustion, but if the condition of the good is altered, which was the case here, remember the little diamonds, the little gemstones. So if there is an alteration, then the exhaustion theory falls to the ground, and then the trademark owner kind of recoup his right to oppose. So infringement for the alteration. And so what about the use of the Rolex trademark on the website? Here, on the other hand, the court didn't follow Rolex. Actually, the court considered that even if Timeline used, so they didn't use the Rolex just in plain normal letter, they used actually the semi-figurative Rolex trademark. It was okay because Rolex already, it was a way to inform the consumer, and Rolex did not demonstrate that that specific use of the trademark on the website was unusual considering the sector, which is second-handed resale of second-handed products, and that Rolex didn't show that the consumer wouldn't be used to such a specific use and would kind of being confused with the fact that there would exist a connection between Rolex and Timeline watches. And for the use of the Rolex trademark on the social media, actually there the court decided there was no exhaustion of rights. Why? Because it was a specific picture which timelines use without authorization. And so they didn't get the authorization to use a trademark that was reproduced specifically in that picture. So that's, you can see that in one same decision, we can have different layer having one infringement and not another infringement. Still in the upcycling use, and here we are with our neighbors in the Netherlands. So this case has been decided quite a few months ago, so recently, and it's a case about Lego. So the defendant is anonymous, at least in the decision that I found online, and he called himself a Lego enthusiast, and he's a member of the adult fan of Lego. Actually, well, my companion is a fan of Lego. I'm not sure if he's a part of that association that's called AFOL. I didn't know of that association, but so it exists. And the guy, so this Lego enthusiast, is so enthusiastic that he creates his own designs of trains, actually, made with Lego blocks. And he also, because his designs of trains were so meeting such a success online, because I think he has a website or something, and so he was showing his designs, and they had such a success that he decided to offer building sets to consumers with the customized Lego elements. Okay, and what does this Lego enthusiast do actually? And you will see here the illustration on the right or left side of your screen. So what he did, when you see the little red bricks, actually he kind of pierce a hole in those little bricks in order to insert a metal ball bearing. I don't even remember what it means in French, but you can see the illustration. It means that it can then use those bricks and pack a little metal bar inside of the hole so that the bricks will all together even when they're not stuck up over each other. And another use he was making of these Lego bricks is that he would he affixed actually third-party names, logo, trademark on the Lego bricks. As you can see on the train, you see some signs and trademarks that have been affixed, and actually they are affixed and printed in a definitive way. So you cannot just take them off. So they're there and they're there to stay. And important fact, on its website, this Lego enthusiast actually put a disclaimer saying that it was his website and that it was not supported specifically by Lego. And actually, so what is the decision? The decision, it's clear that we use the same sign as a trademark for the same goods or very, very similar goods. So the question was there, is there an exhaustion of rights? So because Lego put the bricks on the market, is it okay for this Lego enthusiast to then just use these bricks and do whatever he wants with it? Here, actually, we see that the good have been altered. So this condition to which already referred in order to kind of limit the exhaustion of right theory exists. The condition of the good has been changed. So in principle, there should be no exhaustion. But the court did, even though in principle, the court could have said there is no exhaustion already. The court did go into and check if there was legitimate reason. The Lego enthusiast said, but no, there's no legitimate reason because Lego itself encourages the reuse of bricks and the fact that we will make our own design. Well, for those who know Lego, maybe they knew that, I didn't. But actually, the court did not follow this Lego enthusiast argument, and the court followed Lego, saying that yes, there is legitimate reason to act because there is an alteration of the goods, and so in itself, it should be sufficient to consider that there is no exhaustion of right. But in this specific case, even if the court had to go further, the court said that here, the alteration of the goods is such that Lego cannot guarantee the quality of the good anymore, which is one of the essential function of the trademark. And there is also a potential issue with the identification of the origin of the good. So we consider that there is no exhaustion of right. And even if there were disclaimers on the website, saying it's not legal, it's me, I altered the goods, the court considered that this disclaimer were not enough to counter any risk of post-sale confusion, because if those who were buying on the site could indeed maybe it was clear enough for them that they were not buying, products from Lego itself. Afterwards, other people seeing those products or people that would rebuy that product, they could not know where those products were coming from, and they would be able to confuse them with Lego products. Then we go into the debranding and rebranding examples. And here we go at the European case law level. And so that is a famous case of which Lora spoke to you already, the Mitsubishi Duma. And so I'm not going back on the facts. So the Duma had those forklifts, and they bought it in order to import them in Europe and to sell them in Europe. And they debranded those forklifts and took the Mitsubishi brand off to put their own brand. And one important fact here is that actually Mitsubishi did not put the forklift on the European market yet. So they did not, Mitsubishi did not enjoy this first sale advantage within the European market yet. So if you listen to me well, or if I was clear enough, you may see already where we are going, because actually Mitsubishi did not put the goods into the European market itself yet. The court considered that the exhaustion theory could not apply, and that because there was clearly a use without Mitsubishi consent and clearly a use in the course of trade, because the intent of Duma was to resell actually those goods into the European market, then there was an infringement of the trademark. And here that's quite interesting to know that the Advocate General went for another direction, and the Advocate General advocated for no infringement, but the court went another way. And that's not the only time that we can see that conflict, that opposition between the Advocate General and the final decision of the court. Still in debranding and rebranding, it's a Viking gas versus cousin gas. Again, it's quite old, but it's really important to refer to it because that's still the case to which we'll refer in similar circumstances. And here the circumstances is that Cousin is a company that sells bottles of gas that are protected by trademarks. So the bottles as such is protected as a trademark, and then the sign Cousin affixed on the bottles are protected as trademarks. And those bottles can be reused and refilled, and Cousin do offer the service to refill. And on the other side, we have Cousin's competitor, Viking, that only offers a service to refill these empty bottles of Cousin, for example, and to exchange those empty bottles for full ones. And once Viking receive an empty bottle from Cousin and refill it or exchange it, it will give back to the consumer a bottle that is re-stickered, if I may say, with Viking's trademark, while the Cousin's trademarks are still visible. So the whole question was to know, is it okay to appose your own trademark on this used product that you refilled, while you still let the original trademark on the product itself? And so that is it confusing for the consumer to be faced with those two trademarks? Then you come to the European proceedings. And first, and it's an important point here, is that the court noted that the bottles of gas are a specific, it's a product in itself. So the bottle is not only the packaging. So the bottle is worth money, and it has a considerable worth. And the court considered that when the consumer bought the bottle, the price they paid was quite high, because they paid a part for the bottle and a part for the gas inside the bottle. And once the bottle was empty, they will pay less to just re-put gas into the bottle. And so in some way, when they bought the bottle the first time, the consumer became the owner of the bottle and should be able to use this bottle, that it's his own bottle from this first sale, as his wish, and should be able to go and refill it even to a competitor. And the Cousin's claim that will have for effect to force the consumer to return to Cousin would be a limit to the freedom of the consumer to use a bottle that he owns as he wishes, and would be also an undue restriction to the competition in the market of refilling gas bottle. And so the court considered that the bottle as such and the right on the bottle as such were exhausted, so that Cousin could not oppose the further use of those bottles, and by Viking, and the affixing of other trademark, while the original trademark remained on the bottle. But so the court, just, it's a temper, said, of course, if the trademark owner cousin can show that he has a legitimate reason to oppose further commercialization, then he should be able. But if you read the decision, you see that it doesn't seem to have a reasonable and legitimate reason. And then a very similar case on which we'll go quite fast, but it's interesting to see because I told you this cousin Viking was quite old, but it's still super relevant today. It's a case of 2022 of the SodaStream My Soda. They both sell applications that will allow the consumer to prepare carbonated drinks from tap water. It's a quite nice appliance to have. I have one, I like it. And My Soda actually at one point sold bottles filled with the carbon dioxide that you need to carbonate the water, and that those bottles of carbon dioxide were compatible with the both machines, so from SodaStream and My Soda. And some of those bottles that were sold by My Soda actually were bottles that were initially marketed by SodaStream. So here it's exactly the same that what happened in Viking Cousin. What My Soda did, they took used old SodaStream gas bottle, and they just affixed a new sticker with the My Soda brand on this gas bottle next to the SodaStream brand. And here, well, no surprise, the European court went in exactly the same direction and considered that it was okay at first view, such a use, and that there was an exhaustion, and so that SodaStream could not oppose My Soda use of its trademark opposed on the gas bottle. Of course, again, depending on the specific case of if there is no legitimate reason, but here the court kind of assumed that there was no specific reason. And then another interesting case, and here it's the BMW, again, an old one, but still relevant today, is you will remember in one of Laura's slides about repair, she had this slide about a garage, a car repair that was specializing in repairing cars, and in front of the garage you could see that he was using trademark from a car manufacturer, and here it was a specific, so the garage was Debranding, and he was actually using and referring to BMW and presenting himself as being the BMW specialist to inform people that he was actually repairing BMW and offering repairing services for BMW. And the court said, the case went to the court, and the court said, as long as the use of the trademark BMW is done in such a way that it is to inform the consumer that actually the service is directed to BMW, owner of BMW car, and that Debranding will offer service to repair those BMW cars, then it was okay. But if the use was to mislead the consumer and to say, oh, I'm connected with BMW, so I'm not just repairing BMW, but I'm commercially linked with the company BMW, then it would have been misleading and it would have been an infringement. And again, all those cases must be read, one with each other. That's a case here, super recent, beginning of this year in 2024, and that's a case about Audi. So we have a third party, so it's not Audi, so it's a third party that sells spare parts for cars. And one of the spare parts that he sells is actually I don't know if the English word is radiator, but I translated it as a radiator for Audi, so specifically intended for Audi older model. And on this radiator, you could see at first view no trademark. So you may think you see one, but there was no trademark. But actually, you can see that the radiator contains an element that is specifically designed so that you can clip actually the Audi emblem, just like this. And so, of course, Audi was not super happy about this. And the case went up from Poland up to the European Court. And the European Court here decided that it was going a bit too far because this third party, so JQ, tried to argue that he was using this element designed so that you could attach the Audi emblem just as a referential use, and that it was just to show that this radiator could be used for an Audi, but the court considered that it was not the case, and that actually they really tried to reproduce one of Audi's specific product, and so it was going way beyond the information argument, as we said in the BMW Debranding case. And then seal on repair, and that's going to be super fast because Laura went over this already. Here the court considered in this Ligne Rosé case that actually there was no exhaustion of right because Ligne Rosé could actually oppose legitimate reason to Fitesso. Legitimate reason, why? Because first the court reminded us that as soon as the good is altered, it should be sufficient to say that there is no exhaustion of right because in the legislation, be it at European level, be it at the Benelux level, it is expressly stated that one legitimate reason is if the condition of the good is altered. So it should be sufficient. But again, the court said here, okay, even if we do not need additional condition, if we were to look for additional condition, as Laura said, here we have additional condition because we consider that the alteration is such, you change the foam, you change the tissue that you put around the sofa, you even affixed the label. This is going too far, and this is potentially undermining the function of warranty of quality. And an important fact is, interesting fact is that this super similar case, I'm not sure that it was the exact same sofa, was also ruled in Paris super early, so a few months ago, and the Paris court came to the same decision as to the Brussels court. And then I'm just going to fly over this slide, and actually it's a bit of food for thought, so we will be on time, don't worry. And for those who know me, it's quite surprising that we'll be on time. So it's just really a few pictures, just to provoke you, to make you leave with more questions so that you have to come back to us maybe. Here I put some example of the Louis Vuitton upcycling and also of some Chanel upcycling. So the Louis Vuitton, well, it may come from a bag, it may come from a belt, it's not clear. On the Chanel side, we know, and maybe you can see that actually Chanel also have jewelry, but that's okay, of course. But the jewelry that are not from Chanel, actually it's a third party that reused Chanel button and that made jewelry up with that Chanel button. Okay, in both cases, Louis Vuitton and Chanel, they did sued the third party using the trademark. And as far as I know, almost each time they settle. So I'm not aware of a specific decision, and most of the time they settle. So you may wonder, so why do they sue if at the end of the day they settle? Because what is important for Louis Vuitton and Chanel and those other luxury brands, and it's understandable because they invest a lot in their brands, and Laura said it, it's also to protect their brand image. So if they don't do nothing, the risk is that the market will be overflowed with, and again, I think upcycling is really nice, and it's a concept that should, be developed, but it cannot be developed at the detriment of the trademark owner and the right that they have and the investment that they made for the product. And if the market is overflooded with Louis Vuitton and those Chanel products that are not from Chanel and Louis Vuitton, and that Chanel and Louis Vuitton cannot control the quality of the product, then we can understand that they have a potentially brand image issue. And same with those little cushions. Here, we are not aware of a fact that those cushions will have been the object of any specific proceedings. But you may wonder, is this use okay or not? And is the fact that they specifically decided to keep this little red Levis label, isn't it a bit too far? Maybe they could have done the same, not using the little Levis red label. So we can wonder whether they did that because they knew that they will be able to free ride more on Levi's reputation by using those labels. I'm not saying that's my opinion. I'm saying we can wonder. And the last slide, promise, on my side, and then we conclude, is two initiatives, well, actually three, and you may have heard about it, from Miscellaneous Mischief. It's super difficult for me to pronounce that word. So it's a company based in the States that actually kind of like to play with the market and to do like hit sales. And so they bring products on the market, so they upcycle products, and they like to do something provocative. So what they did, for example, they did what they call Satan shoes and Jesus shoes using Nike models. So they bought the original Nike model that were put on the market by Nike. So we could say that there was an exhaustion of right, but what they did, for example, for the Satan shoes, they put, supposedly blood from the employees in the sole. And then you can see the sign 666 of the devil on the back of the shoes. And then they refer to a verse of Luke saying, I saw Satan fall like lightning from heaven. And on the Jesus shoe side, they put a cross, they put a reference to a verse from Matthew, and supposedly they put holy water in the sole. Of course, Nike was not happy, and they sued this miscellaneous mischief, and finally they settle. And on the other side of your screen, you see still another example from miscellaneous mischief where they decided to do a Birkenstock with Birking leather. So that's also a type of upcycling. Here, I'm not aware of the fact that Birking from Hermes, so it's one of the famous bag. I don't own one bag from Hermes, but hopefully one day. So I'm not aware of the fact that Hermes would have sued the use of their leather to make the Birkenstock, but that's another example of upcycling, and one could wonder whether it should be considered as an okay use of a trademark product. And that brings us to the conclusion. For my part, I already thank you, and I will give the word to Lora.
Yes, so I will be very brief on the conclusion. So we could state that the practices of upcycling, recycling, debranding, all of those things, that it really presents a very innovative pathway to sustainability, to reduce waste, to foster a circular economy. But however, we also must bear in mind to ensure compliance, to avoid trademark infringement. And as we know, as we have seen, as Sophie has explained, that the Court of Justice mostly does support the trademark owner's perspective. So that's very important as an upcycler to keep in mind. Very short, also sustainability shouldn't be or doesn't have to be confusing. So we have seen that upcycling really helps society's general goal for a more sustainable future. However, trademarks should really be protected at all costs. So upcycling businesses should be mindful of the presence of others' trademark rights, and it's very much recommended that upcyclers really take sufficient measures to ensure that the consumers, the public, really can distinguish the new upcycled goods from the original trademark goods, to avoid giving the impression that a new upcycled product actually originates from the original trademark owner. To avoid creating any suspicious economic link or association between the upcycler and the original trademark owner. Now, as to protection measures that could be taken from the trademark owner's side, we would firstly, of course, state be as transparent and precise as possible in labeling. Always mark very clearly what your goods are, what your trademark is. Also very important for the upcyclers to prevent misleading consumers and to always be very transparent about what the origin is from the trademark goods. And then as to partnerships, I think it's very important to also state that there have been some sustainable initiatives from trademark owners themselves, such as licensing agreements, which can support the reuse of the branded goods while also maintaining the brand's integrity. So we have two actually very interesting examples from luxury brands which have been very proactively partnering or directly even competing with upcyclers by, for example, creating their own platforms to transform old damaged pieces from their luxury brands into new pieces of clothing. So, for example, Loewe has started their own project to upcycle fabrics from their previous collections to create new designs. And also Louis Vuitton has actually created their own online shop, which is called Nona Source, to actually resell at a very affordable price their unused fabrics from their previous collection, but also from high-end brands like Louis Vuitton, Christian Dior, to sell them at affordable price and to actually upcycle it. So that's also very interesting. And of course, besides these more green initiatives that upcyclers and trademark owners can undertake, enforcement through litigation is also always possible. Firstly, by informal enforcement, warning letters, takedown requests, and then eventually potentially litigation. So I don't know whether Sophie has anything to add, but I can conclude from my part.
Conclude.
Yes.
Yeah, so I think that's it. Thank you for joining us. If we run out of time, so well, if you guys want to stay all the afternoon, we are ready to do that with you. But if not, as stated, do not hesitate to send us a word. The email is in the presentation that we will send you actually, and we'll add our email. We will send the presentation, and don't hesitate to send an email, to call, and hopefully we'll get a chance to see you in real life another time. Have a super nice afternoon.